Imagine this scenario. You're a police officer in full uniform responding to a domestic violence call. When you get to the scene, an average sized man holding a baseball bat starts walking quickly towards you. You give commands for him to stop and to drop the bat, but he doesn't comply. He keeps moving towards you. What do you do? Do you shoot the man? Do you try and tase him? Do you try and grab the bat out of his hand? Do you try to deliver fist strikes? Or do you run away? I'm Steve Serbalik, and I'm a panel attorney with AsCops in Arizona. Keep that man with a bat scenario in mind, as today's topic is the problem with the use of force policy recommendations found in the 2020 U.S. Conference of Mayors report on police reform and racial justice. As always, this is a topic summary and not legal advice. If you have questions about any specific circumstance, make sure that you consult a lawyer. So to start, as a quick refresher, remember the legal standard for police uses of force is found in Graham versus Connor. I've done an entire series on this very important case, and the standard set down is that police officers need to use force that is objectively reasonable to address the situations that they face. The Supreme Court said that determining whether a use of force is reasonable is based upon the crime that was committed, whether the suspect is an immediate threat to the officers or others, and whether the suspect is fleeing or actively resisting arrest. Graham versus Connor hold that courts will look at all of the circumstances officers faced when using force, and they'll evaluate whether that use of force was reasonable from the perspective of the officer at the time. Now, this makes a lot of sense. Let's apply that to the guy with the bat scenario that I laid out at the beginning. Is it reasonable for the officer to shoot that man? Maybe. It depends on the totality of the circumstances. Is it reasonable for the officer to tase that man? Again, maybe, depending on how close the officer is to the man, the size of the man, whether the backup is available for the officer, and a whole host of other factors. Should the officer grab the bat? Well, I suppose the officer could do that, but that's a pretty dangerous situation to place the officer in. Should the officer try to shoot the bat out of the man's hands? Police training says no, as officers are trained to shoot at center mass to stop a threat. Should the officer try fist strikes? Probably not. That would place the officer at a huge disadvantage when compared to a man holding a baseball bat who's refusing to obey commands. Whatever option the officer chose, courts would evaluate that choice to see if it was objectively reasonable. Now, let's compare that to the new proposed standard being advocated in the mayor's report. Here's the quote from their report. Department policies and training programs should specify that officers use only the minimal amount of force necessary to safely resolve an incident, and that they should exhaust all alternatives, including providing a verbal warning when possible, before using deadly force. Let's apply that standard to the scenario of the man with the bat. What is the minimal amount of force necessary to address him? If the officer shot the man, aiming for center mass, and he shoots the man twice instead of once, has the officer exceeded minimum force? What if the officer doesn't stop the threat with that first shot? And if the officer does shoot, was that the minimal amount of force necessary? Did the officer need to aim for center mass, or must the officer have tried to shoot the bat out of the man's hand? Or is the officer forced to try to grab the bat or engage in fist strikes? Even if that means the officer would be exposed to potentially being hit in the head by the man holding the bat. I hope you see the problem here. While it's certainly acceptable to expect that an officer involved in a use of force situation acts reasonably and not excessively, the standard under Supreme Court case law, the minimal amount of force necessary policy is impossible for an officer in a moment, because that creates an impossible choice, as the officer needs to decide what the minimal amount of force necessary actually is. Another problem with the mayor's standard is this. Under the minimal level of force language, who decides what the minimal level of force is? What if one officer believes that she can use a control hold, but another officer believes a taser is necessary because he feels he lacks the strength or dexterity to effectively stop the threat? Is the officer who uses a taser violating the minimal force necessary policy, and is he now facing termination because he felt a different technique was appropriate? Graham versus Connor remains the law of the land, and the objectively reasonable standard will remain in federal court, but agencies could make the huge mistake of adopting the mayor's report language of minimal force, which could subject officers to discipline or even termination if they don't guess correctly as to what the minimal amount of force necessary is in any given situation. This is completely unreasonable and will lead to officers being second-guessed with an impossible standard, and could very likely lead to officers placing themselves in dangerous situations that could get officers hurt or killed because they did not know what a review board sitting in the safety of a conference room would look back on and view as the minimal amount of force necessary to address any given situation. Officers have been hurt or killed because they underestimate the minimal amount of force needed in split seconds. If violent suspects aren't effectively controlled, they can attack officers or others, and a miscalculation could give a suspect the opportunity to gain a tactical advantage and engage in more violence. Additionally, there's another problem with this policy outside of the scenario that I gave you. Let's say that after giving warnings and an opportunity to surrender to a suspect, officers on a scene decide to deploy a police canine on the suspect. But the suspect later claims that he would have given up if the officers had just given him more time. Did the officers that used the canine break this minimal policy? Under the Graham versus Connor test, the answer to that question is based upon the totality of the circumstances, but under this minimal force policy, the officer's decision to use the canine would be against policy if in 2020 hindsight, it went beyond what was minimally necessary. This second guessing would cause officers to hesitate and could prolong dangerous situations and endanger civilians that call the police to address crimes in progress. And finally, here's an aspect that you won't see in media stories. The data backs up the proposition that most uses of force under the current legal standard, the objectively reasonable standard, are appropriate, and officers effectively respond to dangerous circumstances well. The mayor's report language of minimum force will, by design, cause officers to both hesitate to respond to dangerous circumstances and will place officers and civilian victims in increased danger. I'm Steve Serbalik. Thanks for watching. Stay safe out there. If you're interested in watching another relevant video, click up here. And if you'd like to subscribe to the channel, click down here. And then hit the notification bell to receive messages when new videos are posted. Videos are posted every Sunday at 5:30 p.m. Arizona time.